All right, let's pull back the curtain on one of the weirdest, most powerful parts of the UK Constitution, the Royal Prerogative. I like to think of it as a kind of constitutional ghost, an ancient power that, believe it or not, still walks the halls of government today. So yeah, let's dive right in.
So let me just start with a question for you. What if the government could decide, on its own, to send the armed forces into a conflict? Or what if it could sign the UK up to a huge international treaty, all without needing to pass a law or even win one single vote in the House of Commons? I mean, that sounds kind of crazy for a modern democracy, right? Well, here's the thing. It's not crazy, because it can. The UK government can do exactly that, and it does it using this old, almost phantom-like power called the Royal Prerogative. This is the power that really exists in the shadows of the UK's unwritten constitution, and today we're going to drag it out into the light. So what are we actually talking about here? What are these hidden ghost powers that government ministers can use in the name of the crown?
Okay, so if you want the classic legal definition, the great constitutional scholar A.V. Dicey called it the residue of discretionary or arbitrary authority. Just think of it like this. It's all the powers that the monarch used to have back in the day, powers that have just never been officially taken away by Parliament. They're basically the leftovers of history, but, leftovers with some serious punch. And this quote, it absolutely nails the central drama of the whole thing. See, the monarch doesn't really use these powers anymore. Over the centuries, they've kind of migrated from Buckingham Palace right over to 10 Downing Street. Today, they're used by the Prime Minister and other ministers, which, as you can imagine, raises some pretty big questions about democratic accountability. And listen, we're not talking about small ceremonial stuff here. This is the core business of running a country. We're talking about the power to make or break international treaties, the authority to send the military into action, the power to pardon someone for a crime, and even something as basic as deciding whether to give you a passport. These are real powers and they affect everybody. But this power, this ghost in the machine, isn't totally free to do what it wants. Over the years, it's been slowly brought under control. And the very first institution to start forging those chains was Parliament itself. Okay, so the fundamental clash here is actually pretty simple. You can think of prerogative power as an old unwritten house rule. An act of Parliament, on the other hand, that's the official supreme rulebook. And in the UK's constitution, when an old house rule bumps up against the official rulebook, the rulebook wins. Every single time. That's the core idea of parliamentary sovereignty. And this big showdown really came to a head in a landmark case right after the First World War, way back in 1920. The case was called Attorney General versus De Keizer's Royal Hotel. Now, during the war, the government had used its prerogative power to take over this hotel for defense purposes. The hotel owners said, fine, but you have to compensate us. The government's argument? Nope, the prerogative doesn't say we have to pay you. So this case just perfectly lays out the constitutional pecking order. The court said, look, sure, a prerogative power to seize property does exist. But Parliament had also passed a law, the Defense of the Realm Act, that covered the exact same situation. And that act said you have to pay compensation. The government couldn't just ignore the act and use the older power. It had to follow the rules Parliament had written down. The rulebook wins. So the takeaway from this is crystal clear, and it became a cornerstone of constitutional law. An act of Parliament, a statute, is king. If Parliament makes a law about something that used to be covered by the prerogative, well, the prerogative has to shut up. It gets put on the shelf and can't be used. But Parliament wasn't the only one trying to rein in this power. The courts also started drawing their own legal lines in the sand. So our next key date is much more recent, 1985. The political vibe is pretty tense, and the government is making a really controversial move that affects workers and national security. This is the famous GCHQ case, and it was a huge deal. Before this, courts might say whether a prerogative power existed or not, but they wouldn't get involved in how the government used it. But here, the House of Lords made a massive change. They said, you know what, from now on, the way a minister uses a prerogative power can be challenged in court, just like any other government power. This source of the power wasn't a magic shield anymore. But, and this is a really important but, they created a new test. They called it justiciability. Basically, is the subject something a court should even be ruling on? They decided that big, high policy stuff, like national security or foreign treaties, was non-justiciable. That's best left to the politicians. But decisions that affect individual rights, like issuing a passport or making sure a process is fair, oh yeah, that was definitely justiciable.
the courts could and would get involved. And all of this brings our story right into the 21st century, with what was maybe the biggest constitutional test of these ideas in living memory: Brexit. The year is 2017. The UK has voted to leave the European Union, and now the government has to figure out how to actually do it. So the government's position was, hey, we can use our prerogative power over foreign affairs to trigger Article 50 and get this whole withdrawal process started. But was that right? Could they actually do that? This massive question went all the way to the Supreme Court in the now famous Miller I case. And the Supreme Court's answer was a huge, emphatic no. And their logic? It sounds a lot like that old De Keyser Hotel case. They said, look, the prerogative is for external stuff, foreign affairs. You can't use it to change the law inside the UK, and you definitely can't use it to take away rights that Parliament has given people. And since that 1972 Act, the one that took Britain into the EU in the first place, had created all these domestic legal rights, only another Act of Parliament could start the process of taking them away. So, after centuries of being chained down by Parliament and the courts, you have to wonder, is this constitutional ghost finally tamed? Or does the fact that it's still a bit shadowy pose a problem for a modern democracy? This all leads to a really big debate that's still going on. Should we finally get rid of this ghost altogether by writing all of these powers down in law? It's a process called codification. On one side, you have people saying, absolutely. It would make things clear, it would make the government more accountable, and it would stop them from trying to stretch these vague powers. But on the other side, people argue that the current system is flexible, which is really important in a crisis. And they worry that if you write it all down, everything will just end up in court, which basically hands power from our elected politicians to unelected judges. You know, there might be a middle ground here. Instead of one giant law trying to cover everything, maybe Parliament could just pass specific laws for specific areas. You could have, say, a War Powers Act that clearly lays out the rules for deploying troops. That way you get more clarity and a role for Parliament, but you don't lose all the flexibility of the current system. So that leaves us with the big question, really. The royal prerogative started as the absolute power of a king or queen. Now it's a tool for ministers, one that's kept in check by Parliament and the courts. But here in the 21st century is a power that still kind of operates in the shadows, tamed only by old traditions and court cases. Is that really good enough? Or is it finally time for this ghost to be captured once and for all in black and white?